step, LD 461, an act regarding private roads presented by Senator Vitelli of Saginaw.
Good afternoon, Senator Nangle, members of the Joint Standing Committee on State and Local. My name is Eloise Vitelli, and I proudly represent Senate District 24, which includes all of Saginaw County and Dresden in Lincoln County. And I'm pleased to be here today to present to you LD 461, an act regarding private roads. Last year, the Maine Alliance for Road Associations asked me to submit the legislation before you today. Since then, MARA provided me with additional draft language and comments explaining that language. I was considering proposing an amendment based on that document, but between submitting the bill and receiving MARA's feedback, I've learned that this committee has already been working diligently on the issues that this bill seeks to resolve. In the 130th legislature, the State and Local Government Committee voted to create the Abandoned and Discontinued Roads Commission. In February of 2023, this year, the commission presented its first report to the committee. It's my understanding that the commission's report addresses matters that are related to some of the changes included in my original bill draft, as well as the additional draft language and comments that MARA has sent to me. In fact, this committee has already asked the commission to review LD 461 and provide feedback to the committee either during the public hearing or the work session for the bill. I would certainly like to hear the feedback and listen to the related discussions. I'd also request that the committee review MARA's letter, which I believe has already been distributed to the committee and to interested parties while you all continue to engage with these issues. I will add that I had heard from a number of my constituents over the past few years who live on private roads and who are looking for clearer understanding of how their roads are managed. I am in hopes that the above mentioned conversations can help provide greater clarity and guidance to those who live on these roads along with their neighbors. I thank you for your work on these matters, and I thank you for your time. I will do my best to answer any questions you may have.
Does anyone have any questions for the senator? Go ahead.
Just real quick, simple question. We dealt with something similar down where I used to be a selectman. When the town takes over a private road, and it's usually done out by a referendum, they'll go out and vote to do that. But the other side of that is too, if it's a private road, the taxpayers of that town typically don't want to maintain a private road, when usually under contracts, that private road is supposed to be maintained by whoever put the road in. So, I mean, so to be clear, this is just a turnover private roads of the town to flip the bill to take care of them?
I don't think that's the full intent. No, I think they're really looking for a better definition of what is a private road. I mean, I have to say I learned a lot through this process. I'm still not entirely clear all of the distinctions, but there are different kinds of private roads. Some have associations that govern their maintenance. Others are more informal. I personally live on a private road, if you will. There's only 3 of us, and we just manage it on our own. So it's really sort of the different levels of what constitutes a private road and what people's recourse or what their structure is for how they can best maintain those roads that's in question here. And what I think both the organization, the association, and my constituents are looking to better understand.
Yeah, the only reason I asked is just because cost of salt and everything went through the roof in the last year. And a lot of people, private roads, they're not really doing nothing but skimming them. So, but
If that.
yeah, well, yeah, but again, they're still private. That's the key. But
Yes.
anyway, thank you.
Yes, I agree. So just basically greater clarity, so people can be best informed, and then it's going to be up to them to maintain their roads as best they can.
Any other questions? Okay, thank you.
Thank you, Senator.
Okay. Seeing no other sponsor or co-sponsors, is there any other co-sponsor here that would like to speak? No. All right, so we will now take public comment from members of the public who are in favor of this bill. And again, I'll remind you that we're going to limit your comments to 3 minutes.
Senator Nangle, members of the Committee on State and Local Government. My name is Andrew Allen. My nickname is Sandy, if you have questions to direct to me. I live in Freeport. I represent the Maine Alliance for Road Associations. We also call this group MARA, and I am testifying in favor of LD 461. MARA is a volunteer public service nonprofit corporation. Our main purpose is to gather and distribute information and educational materials to road associations who are forming or who have formed and are operating according to the Maine Private Ways Statute, sections 3101 to 3106. In addition, we advocate for fair and equitable laws relating to private road associations and to residents living on private roads in Maine. We gauge the interests of our membership and the public through frequent email communication, member posts on our website discussion forum, and participation at our annual private road conference, which is open to the members and public. The goals of LD 461 as amended include clarifying terminology around the term private way, easing notice of claim renewal requirements, providing for installation of pavement and maintenance of existing pavement, permitting reserve accounts, and quantifying the increasing number of Maine's private roads with 4 or more parcels that are maintained privately. MARA would like to thank attorneys John Cunningham and Mary Dennison for their pro bono work to clarify the confusing terminology surrounding 3 terms: private ways, private roads, and public easements. We had begun to do this, and Attorney Cunningham encouraged us to expand the number of statutes involved. Attorney Dennison joined in, and as we speak, she and her paralegal team are choosing the appropriate terms for between 30 and 40 statutes with confused terminology. This work will become our Addendum 1 to the letter of March 13th, 2023. Attorney Cunningham's experience and expertise are responsible for most of the withdrawals in our amendments. He helped us to insert the pavement installation and the reserve accounts amendments. I think it's remarkable that these 2 busy attorneys made time to help us. MARA is grateful to both of them. We favor LD 461 because we believe that the changes we propose are in the best interests of private road associations and people living on private roads in Maine. Thank you for your time. Do you have any questions?
Does anybody have, go ahead.
Thank you for your testimony. Does this change in wording favor the association over the municipality?
Which change in wording are we talking about? The easement and
Private way, private roads, private easement. I mean, does it put one against the other in any way?
I don't think so. I know that the town of Wyndham, and someone here in the House may be able to speak more clearly to this, but they have asked the people on private roads to make their roads public easements so that they can take over some plowing duties that they've had for years and make it. But I don't think there's competition here.
Good.
It's a matter of clarifying just what these terms are, as Senator Vitelli pointed out.
Just a second question. So if in a town ordinance, you could get it changed to public easement, it might be better for the people living on that public easement to at least get their road plowed in the winter.
I think it's a local decision.
Yep.
But yes,
Voter approved.
that could work.
Voter approved would be,
Yes.
Well, it could be, however, the town approves that in Wyndham, where I was a town councilor, we, the council approved it. But we had similar questions as to what a private way was and what a private road was. And I think we kind of came up with the fact that they both meant the same thing. They were, they were used interchangeably throughout the town's ordinances. And the public easement gave the town the ability, at least in Wyndham, gave the town the ability to provide winter maintenance, but no other maintenance. And that actually just came before SLG last year and the town was attempting to do what with that? Go ahead. Yeah.
The issue was that the town had been plowing private streets in the city of Wyndham, and that is illegal. So they came to us, it was in a turnover of city managers, and the new one caught this, came to us and said, hey, we have a real big problem here. They were able to work it themselves, but when they came here, my big question was, you're talking about ownership of property and it being transferred to the city. And they had a lot of people from away who just came there from summer housing. They were having difficulty contacting everyone. I see this as a nightmare. And this runs deep. This is in people's deeds. This is in the registries. I'm quite concerned about this.
We would like to see the elimination of the term private way and make it essentially taken over by the definition of a public easement so that the two are synonymous.
I would also wonder, we have an abandoned, the other committee that is, or commission, I forget what it's called, but they're looking at all of these things. And I think that that's going to play into this very much. And I think changing, I've lived on a private way. I've lived, there's road maintenance, and they may have their own road maintenance agreements for private non-homeowner association private ways. I think this is a ball of wax that's just very complex. It's going to confuse all the filings in the registry, because my land in Cumberland, we had a private way maintenance agreement. So do we have to go back in and have that? I just think that lawsuits are going to be everywhere on this. I'm quite concerned. I understand the ambiguity of the language, but I think it needs much more vetting.
Well, we're very fortunate to have Mary Dennison working on this. She's one of several attorneys in the state that are recognized for their knowledge of the private way statutes and roads and laws dealing with private roads. So she has that in mind as she's going through these statutes and trying to clarify them.
I wonder, we had the committee, the Abandoned and Discontinued Roads Committee, has a real estate attorney on there, but I wonder if she is involved with them. And
I can't address that.
yeah.
Okay.
Thank you.
Does anyone else have any questions? So I have a question. Boy, have I got questions. What do you currently, from your perspective, what is the definition of a private way?
I wish I had the letter that we wrote in front of me, because in that it talks about two statutes that define private way in reference to a public easement. The term private way has been superseded by the term public easement as defined in MRS 3021 and MRS 3022.
So private way and public easement are pretty much
Yes.
one and the same.
Yes,
Okay,
that would kind of eliminate the one term that's hanging out there, and it would give it a home, so to
So-
speak.
we want to nix private way.
We do.
Okay. What is a private road?
A private road can be a driveway, or it can be a road to a home. Private roads, to try to make a definition of private road as a state level, at the state level, was advised against by Attorney Cunningham, saying that the term private road is so multifaceted and it belongs to so many roads that it should be left to the municipalities to make the decision of what's a private road in their area.
Do you think that the state defining what a private road is would help solve some of these
No,
problems?
I don't. I think it would complicate them and it would be contentious with the local, with municipalities. From what I've heard, I'm no expert.
Okay. Okay. And we do have the definition of public easement.
Yes,
Okay, and that's okay.
yes.
The definition of public easement is okay. 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 Go ahead.
There it goes. Thank you. We don't have any testimony from this attorney. And is she in the room here?
No.
Okay,
So
thank you.
can I have that letter back
Yes,
now?
and thank you for letting me borrow it.
Well, you might want to hang on because I have another question, I think. So, in this, there is some approach signs, any business or facility whose principal building or structure or point of interest, which is located on a private road, more than 1,000 feet from the nearest public way. So it would have to be down a private road more than 1,000 feet, or is not visible to traffic. May erect no more than 2 approach signs. It is, okay, so this is existing language. We're just striking the private way.
That's right. Mara did
Okay.
not, the Maine Alliance for Road Association had nothing to do with the submission of this particular statute for change. Even though it was probably entered by the registry of statutes for
Right.
change.
Yeah,
So we're more interested in the language here and getting rid of the term private way than we are what's going
Okay.
on in the statute.
so that's basically what this does.
Yes,
Sounds good to me. I think that kind of clears things up, is just, I mean, it clears that one. Yeah, there's a ton. I'm gonna say this. I will never buy a house on a private road ever, ever again, unless it's a private road, which is my driveway. And it wouldn't be called a road, it would be my driveway. But anyway, besides the point. Okay, thank you.
thank you, sir.
Is there anyone else who would like to speak in favor of this legislation? Please come up.
Senator Nangle, and members of the Joint Committee on State and Local Government. Good afternoon, and thank you for your time. And thank you to Senator Vitelli for her time and for sponsoring this legislation. My name is Erin Barker, and I live part-time in Phippsburg. I have been the president of our road association for the past 3 years. I am also a board member of the Maine Alliance for Road Associations. I am an attorney licensed to practice in the Commonwealth of Massachusetts. I am testifying in favor of LD 461. Many people will be affected by LD 461, although we just don't know how many. And that is a problem when deciding on important legislation affecting private roads. The provision in LD 461 that municipalities develop or update a list of town ways and private roads with 4 or more parcels maintained privately is a particularly important part of this legislation. Without this information, legislators do not know how many of their constituents actually live on private roads. And therefore, the number of taxpayers who live on private roads. This is an important data point, in my opinion. To share some data, comprehensive plan documents for the town of Phippsburg shows that in Phippsburg, 205 private roads versus only 46 public roads. That's quite a disparity. In the town of Acton, for example, there are 128 private roads and only 32 public roads. Again, that's quite a disparity. And there's no public list that's at least been made available, to the public to identify or quantify the difference in private roads and public roads. And beyond a handful of the municipalities where we've been able to piecemeal this data, no one seems to know how many taxpayers are affected by private road legislation. And I believe that is an important data point. The proposal to replace the 18-month lien provision with a 6-month extension provision for notices of claims would significantly lighten the load and administrative burden of tracking unpaid dues owed to a road association by a homeowner on a private road. As you likely know, road associations operate on a shoestring by volunteer residents. If an extension is missed, even by 1 day, that entire notice of claim is lost, and there's no recourse for the road association. A road association could be tracking a notice of claim for years. And if 1 day is missed at the next extension, that entire claim is wiped off the books. And again, no recourse. The 18 months comes around very quickly when you're trying to track all of this. And extending the provision to 6 years, which I understand is the exact same time frame under the condominium law associations. It's the exact same extension provision that is presently in effect for Maine condominium associations. And it would be a welcome relief for private road associations. I hope you see the benefits of these provisions in LD 461 and vote in favor. Thank you for your time and attention, and I welcome any questions.
Thank you, Mr. Chairman. The previous person's testimony said that alluded to the fact that this was a very specific bill that had to do with changing the name from private road to public easement or something to that effect.
Mhm.
And now you're saying there's another provision in this bill that talks about timeframes for
Notices
notice.
of claim.
So it's actually
It's
different.
there's multiple provisions.
So we have more than one thing going on in this bill. Just to clear that up.
Yes,
And you tested the fact that you mentioned a private road association. So if this bill were to pass the term private way would be superseded by the term public easement. Is that something that many of these private road associations are aware of and are in favor of? Perhaps even changing the name of your group to a public easement association?
Representative, it's a very fair question. I believe, or I understood anyway, and I apologize if I am not as well versed on Maine legislative processes, but I understood that if the bill was being voted on, not every provision within the bill had to be voted on. So I apologize if that's something that I misunderstood. But to answer your question, I don't know the answer.
Fair. Thank you.
So, the original bill doesn't have anything in there about the liens, but it is here in this additional document. And then the other thing is that municipalities to develop or update a list of town ways maintained by the town and private roads with 4 or more parcels maintained privately. That would be a mandate.
What's that mean?
Right? Municipalities need to develop or update a list of town ways maintained by the town and private roads with 4 or more parcels maintained privately. That would be a mandate.
That's my question, exactly. If you could give us your opinion on what the chairman just mentioned, it'd be appreciated. Number of Maine's private roads with 4 or more parcels maintained privately. What does that mean? For that part of the sentence?
I believe the municipalities have this information because they know which roads they don't maintain, right? The municipality in Fitchburg, for example, the municipality knows that they don't do anything for the road I live on. So there is a list somewhere that the municipality holds that tells them which are the publicly maintained roads, the ones that they plow, the ones that they grade, the ones that they maybe do some guardrail work on. Excuse me. They know what roads they maintain. So therefore, and they know all of the roads because they have an inventory of all the roads. But the missing piece is which ones are private. And it's a matter of just deducting from the total number of roads and the total from the total number of roads, the number of roads that they publicly maintain to get the list of roads that they do not publicly maintain.
Follow-up question. 4 or more parcels. Could you define the word parcel?
Well, that's another potential definition problem. You may have a road, and I'll use a private road as an example. You may have a private road that was developed by a developer who had X number of lots approved. And maybe there's a house on there, or maybe there isn't. Or maybe there is 2 of those lots that are owned by the same person. And so I believe that many road associations have their own definition of what a parcel means to them. I do not believe that the term has been defined within the legislature.
Thank you.
You're welcome.
My concern, you just said it, and I was gonna ask the question. So you're right, each town decides what, you got different terminology, and so it could mean anything. But when you switch a private way to a public way or a public easement, now the town, city you're in would be responsible for what you said, grading, ditching, paving. They would be, and they could be held to that if that's upheld. And then with the parcels, and then my other question is, the state just changed their requirements for road frontage for new paving. What happens to the private property along those private ways? Do they lose that by eminent domain?
Representative, I am not in favor of town taking over private roads because it's a constitutional nightmare. Period. That's all that in my opinion, there's nothing else to be said about that because it is unconstitutional.
I think, oh, you're first. I'll go. We're getting down in the weeds a little bit here, and this is probably more appropriate for our workshop on it. And I think members who have specific questions should submit them now to the legal analyst so that she can start her analysis for it. And mine would be in particular, I really want to know what's in this bill, because I just found out there's two pieces, not one piece. So that would be one thing that I would request.
Thank you, Mr. Chair. I would also like to ask our analyst, I believe we may have this information from the other bill
Well-
that we heard, and
Can we finish the public hearing first?
okay.
And
I
then
thought
we
you
can
called for us to-
have our questions
Okay.
for the analyst? How's that?
Well, all right, so then let me ask you, so if I have a private way and I own the street and the other people on the street all just very nicely combine funds and they all work on it together. So you're saying that that private way should be a public easement and others can come and go on it, even though it's owned by me?
I am not testifying with regard to the definition of public way, public road, public easement.
Okay, thank you.
For potentially some clarification, if I may, there are different forms of road associations. There's the statutory based on the legislation. There is a nonprofit corporation road association, which does not abide by the statute. There are combination statutory and non-private road association as one. And then there are the ad hoc associations, like you've identified.
Well,
You
we
have a
don't
couple of
have an
neighbors
association.
who just pool their money.
It's a road maintenance agreement.
Yeah.
So it would just gall me that somebody could say that it's going to be a public easement over my land. Just, that's like stealing it.
And I'm not testifying
Thank you.
on that issue.
Thank you.
Seeing none, thank you.
Thank you.
Anybody else would like to speak in favor of this bill? No other questions. We're gonna move on to the next speaker.
We have some
Yep.
right here.
Yep. I just didn't have my microphone on, so I wanted to cover myself.
That left hook here. Good afternoon. Chair Tim Nangle and Representative Holly Stover. honorable members of the state and local government. My name's Margaret Cardosa, and I live in Portland, Maine, and I have a Wicked Knife camp in Windham, Maine. I'm in favor of LD 461 with some improvements. So, yes, I'd like to see that the word private way be redefined as public easement, because it is. It's called a public easement. Just be aware that because it's just called public easement does not fix what the problem really is. And the problem is that the public has the right to travel on it, but we do not have any policing or funding from the town to maintain it. So obviously changing the word is great, but doesn't resolve the problem. I'm in favor of redefining private road, but the word used in there says restricted. That's not giving us a clue what that really means. So I would encourage that to be looked at. I'm 100% in agreement with removing 18-month extension on notice of claims. I'm a member of MARA, and I have contacted the Maine Realtor Association, which put that 18-month in there, and they are fine with seeing it removed. I've also been outreaching and have gotten some private information from the Registry of Deeds that extension is a nightmare of lien after lien after liens, extensions. It's been difficult. What Mara is suggesting with the 6-year, I am not in favor of that. It is resolved from the Maine Realtor Association. There's another section in there about road construction. I think there's more work on that before that could be passed. Be thoughtful about the issue on summer camps being converted into a year-round. The road isn't wide enough, and as a result, fire trucks can't get through. So we have continued problems. I'm in favor of the municipality reporting about private roads. But I ask you to include 911. I'm opposed to Mara's amendment on the paving. 3/4 vote of all owners is impossible. But I wouldn't mind seeing that July 1st, 2007 struck out. But thank you for your consideration. I wrote more info in here for you to take a look at.
Thank you. Does anyone have any questions? Ms. Cardozo? Thank you. Anyone else who would like to speak in favor of this bill? Nobody online? Okay. Anyone who would like to speak in opposition to this bill?
Thank you, Senator Nangle, Representative Stover, and distinguished members of State and Local Government Committee. My name is Rebecca Cram, and I'm submitting testimony in opposition to LD 461 on behalf of Maine Municipal Association, which represents the interests of municipal government before the legislature. While I understand that there are amendments that are in the work, I haven't seen them nor heard about much of their content to date. So my comments are about the original as drafted. The bill seeks to require municipal inventories, which Representative Adams and Senator Nangle rightly pointed out is a municipal mandate. It's not as simple as just listing the roads that are maintained and plowed. It is establishing the legal status of those roads. It's akin to a municipality drawing a property line and having a boundary dispute with all those folks where there may or may not be an actual problem. Those legal conditions are necessary and they are a very protective process, but they're also expensive. So they're around the legal review, at least to establish what they assume might be a legal road or the status of that road within a community, is around $7,000 to $10,000. And that doesn't include the disputes that might follow, and that would be per community. So it would require the mandate preamble for that. Most communities already have road standards established in their subdivision ordinance and as a requirement for accepting new roads. So there's not necessarily a reason to establish a private road one, and it might actually restrict folks from just making a path into a camp that existed on their own property. They wouldn't want to necessarily have to build that in a way that would allow future public access, particularly if there is none. Also, the inspection of that roadbed is constitutionally questionable because the municipality would then be expending public funds on a private piece of property. Roads that are currently maintained, including all the private roads in the community, already have a state database that is available to the public through the Local Roads Assistance Program. And the Department of Transportation is working on trying to create that as a full list that can be printed out for anyone that comes into that community. And that provides a really good snapshot of what is being maintained, is accessible to everyone in a centralized location, and makes the most sense rather than going town by town or trying to engage in that legal inventory process. With the regards to the definitions of private road, private way, and public easements, those terms are used differently in law because of the functionality of the statute where they exist. For instance, the private way that is established in Title 29A is intentionally all encompassing of the ways in which the term has been used in Title 23 or Title 12 and a couple of other locations, because the purpose of that statute is to allow law enforcement authority to charge an operating offense on those roads or an easement that may have public access, and doesn't really address the legal status of the road. And we understand that that is confusing, but it doesn't supersede the ways in which it is required for those things to be fact found within a court process, and or whether or not it can be legally gated or barred or not gated and barred. And I know that that creates confusion. We know that those terms may benefit from being uniform across, but we need to recognize and go through that process in a really deliberate way. So it's for those reasons that we would like to have the process that has begun with the Abandoned and Discontinued Roads Commission to be able to sort through that and unpick those terms as to where they are most appropriate, so that we don't disenfranchise folks from the ability to have those enforcement mechanisms on those roads, regardless of that definition, or we don't upset and disenfranchise someone because a older definition exists and the new definition, again, as we have done with the roads pretty consistently, it just adds a layer of confusion to figure out at what point in time was this road established, what point in time did the definition change. We do believe that the commission is best suited to do that. It involves all stakeholders, including members of MARA that are on that board, and it is chaired by the preeminent municipal roads attorney who provides this training within the bar. So we know it is being done deliberately, it's being done sensitively, and we want to make sure that we don't create or demarcate a line. So we would ask that you strike the mandate provisions out of the language as they exist, take the definition piece and either table the bill and allow us to continue that work within the commission, or direct us as part of that work and provide us the opportunity to work on that a little bit further. I'll be happy to bring back any additional road related definitions. The binder's about this thick because we've got about 200 years of history around roads, which can be fun to geek out on, but extremely complicated, and anything else that you may need. So, thank you.
We'll come back to you. Questions?
Sure. Thanks.
All right, we're back in session. Senator Lyford has left us, but not forgotten. So I think there were questions for you. Come on back up. I'm really sorry to
No,
break
that's
that
fine.
up for you.
Thank
but
you.
Go ahead.
Thank you, Mr. Chair. Thank you, Ms. Graham, for being here today. And I know you're representing Maine Municipal Association today, but I think you might have some knowledge because of the commission that we're referring to. I think you may be a member as the MMA representative. Do you think it would be wise to take a break kind of on this legislation? And we have a packet about 2 inches thick that we haven't reviewed yet from the commission. Do you think the commission's recommendations should be sought after first before we move forward with this bill?
I think so, because I think there's a level of both understanding of the pain of these and the problems with those definitions, as well as expertise in the background and how they were made and kind of how that web can be sensitively untied. And I think that there's a commitment from all of those members to continue with that. And I think it was a great construction. So
Right. And I mean, just a reminder to anybody who's here who wasn't part of that, this committee created that commission. And it was a very broad spectrum of interested parties that probably are the best experts on this issue. So I just want to let people know that, you know, this is not an issue that we don't care about. It's just an issue that it's a process.
thank you, sir. It may interest the community to know that that membership, that broad membership is also already brought in additional problems for us to consider. So, which is
Good.
why it's
Good.
that thick, but it'll be that thick by the end of.
Yeah, that's even better news.
Yeah.
Okay. Does anybody else have any questions? All right, thank you.
Thank you.
Thank you. Is there anyone else who would like to testify in opposition?
Hi, members of the State and Local Government Committee, my name is David Manter. I have existed in Fayette for 52 years. This is Kayak, much more pleasant than myself. You can read this through if you want, but I'm going to take and abbreviate something. I, in 1971, moved in onto what may have been, there's discussion about it, but it may have been a private way. A private way was a road taken by public authority, all right, that was held in the name of a municipality, but to access private property or public property that was not yet connected to the public highway system, i.e. a dead end road. It could have been subject to gates and bars to keep out unwarranted nuisance traffic, or to let the poor guy who you built across his field keep his sheep all on one field instead of having to, open and close gates to get back and forth. Those are the basic reasonings for it. This is a historical definition that's been around since the king owned this property. All right. So it's not a new one. It was well understood and people knew what it was. There is comment about whether it was constitutional or not. That's in a case law. We also have a public easement. 5 years after I bought my property, you made a law that changed not only the name of what I lived on, but the definition of what I lived on. Now it's a through public road. Now, that's the same thing as the limited user highway in Jordan versus Canton. It's a public road held by the public for which they aren't responsible to maintain. The state Supreme Court said definitively, you read Jordan versus Canton, you cannot have a public road without public maintenance. Not private maintenance, without public maintenance. And forcing people to work on a public road without just compensation is a violation of the 13th Amendment of the United States Constitution. I am neither a slave nor am I an involuntary serf. Sorry, don't like that anymore. But to take these terminologies and try to apply them to private property rights and privileges is a gross mistake. You need to keep private property as private property. If you want to form a set of statutes that if you want a statutory road association, that's fine. People can choose to do that. But you don't allow municipalities to fudge the law to take over a public easement on a private road on a fudge. There is a statutory process for taking these things. They can dedicate it, they can take it by public domain, eminent domain, etc. I'm tired of it. If you're going to treat them like that, I want to be treated the same on the road I live on. Please read this if you want and have fun.
Does anyone have any questions?
I think I've expressed it well enough to know. Thank you.
There is a question, sir.
No.
Thank you. I'm just looking at your testimony and you're talking about ADRC. What is that?
That is the Abandoned and Discontinued
Okay.
Roads Commission.
Okay, that I understand. Thank
That's
you.
my wife. She can tell you about it.
I can tell you about it too.
By the way, that's why I know a lot of what's been going on and why it's been irritating me to no end.
Any other testimony in opposition to the bill? Seeing none? Anybody on Zoom? Okay. Is there anyone who would like to testify neither for nor against?
Senator Nangle, Representative Stover, members of the State and Local Government Committee. My name is Roberta Manter and I live in Fayette. Regarding LD 461, I find myself wearing several hats. As a board member of MARA, I strongly believe in this bill's objectives. MARA and the Abandoned and Discontinued Roads Commission, which I'm going to call ADRA because it's shorter, I agree that sorting out the confusing terminology will require more time. And I think what's happened here today shows how confused everybody is. Nobody's been able to really define things for you. And I hope I'll get a chance to do that in your questions afterwards. As founder of Maine Roadways and living on a road that's been declared a private way and a public easement, the one issue of the terminology and its meaning is of utmost importance to me. My husband spoke on that in more detail. MARA agrees with ADRAC's recommendation to delete the 3 paragraphs 6, 13, and 14 regarding town standards for private ways, or private roads rather. With regard to section 12, I'm glad that Pete Coughlin of the DOT has offered to provide a more readily available list of town maintained roads and E911 information, but more work will be needed to distinguish E911 addresses on private roads from those on abandoned and discontinued roads. Because anywhere that there is an address, that's going to pop up. The ADRAC focused on parts of LD 461 and MARA's proposed amendment that relate to abandoned and discontinued roads. They did not address the parts of it that address private roads. And there is an important distinction there, which I hope I'll get to describe to you afterwards. If you follow their recommendation to hold those parts of the bill over, I hope you can allow the paragraphs regarding 23 MRS 3101 through 3105A to move forward this session. Having been a board member of a road association, I can tell you how urgent these reforms are. The intent of 3101's prohibition against paving was to prevent well-to-do members who want paving from imposing high dues payments on other members for whom that would be a hardship. But it ties the hands of those who need to repair roads that were paved after 2007, but before a road association was formed. Mara's amendment offers options, specifically allowing reclaim, and in 3103, allowing reserve accounts to build funds for long-range projects. What follows is my own personal opinion regarding 23 MRS 3104, not the position of Mara. I was present when the bill was passed that created the 18-month expiration of the notice of claim, and I opposed it then. And some other people have spoken on that, so I'm not going to go into that unless somebody has questions about it. I think it was assumed that most people will pay their overdue dues when a notice of claim is filed, but that's not the case. There are people who have no intention of paying ever, and these claims just pile up one after another. But to go to the question of definitions, I think one of the biggest confusions here, and this is one of the things that we need to sort out, is that a private way and a private road are not the same thing. A private road, and this is where we wanted to put in a definition, but we've been advised not to because it can apply to too many different things. A private road basically is a road that's privately owned and maintained and over which the owner or owners can restrict use or passage. That's a private road. A private way is defined in Title 23, Section 3101, or no, 3021 as a public easement. So a private way is a public easement. A private road is private. So how private way got onto public easement, there's a long history to that, which I could explain if we had a couple of hours, but we don't. But I think that's one of the biggest confusions that really needs to be straightened out. The part that I'm hoping you will send forward are the parts that refer to private roads. That's Title 23, Section 3101 through 3105A. And those are the reforms that we really need to work on. I wish that more of you had had the opportunity to look through both the bill and Mara's proposed amendment to it before we get here, because if you compare those two, you're going to find that there are a lot of things that are crossed out that we were advised, this is not a good idea, don't do this now. And we agree, okay, set those aside. Those are the definitions, the requirements for maintenance standards for private roads. A lot of the places where terminology was changed, the posting of signs and some other things, those Mara didn't even put in. They were put in there by the reviser of statutes. And we have no objection to those being put on hold.
Okay. So does anyone have any questions?
Thank you, Mr. Chair. Just a quick question. Road associations, are they public or private?
Road associations are formed in order to maintain private roads.
No, I don't mean that. The entity itself, a road association, is it a public entity or a private entity?
I'm not sure what you mean by that question. I can tell you how a road association is formed. There are.
Okay, I would say that probably a road association is a private entity. It's not a public entity.
Yeah, I think I would agree with that.
Okay, thank you.
It's a bunch of private individuals that get together for the purpose of maintaining a private road.
Thank you, Mr. Chair. Thank you, Ms. Manter, for being here today. I would probably go on public record to say that you are one of the most knowledgeable individuals on abandoned and discontinued roads that I have ever come across, going back to my service in the 127th. But even most recently, I watched you on a video link for a problem in Androscoggin County in the town of Livermore, I believe it was. And just for people to seek you out because you have this knowledge, I thank you for being here today to testify on this. You reference 23 MRS section 3101 to 3105. Can you talk briefly about those? Because that's what you are suggesting as something to move forward. But I gathered that the remainder of the bill would be something that you would like to see maybe the Abandoned and Discontinued Roads Commission advise on. But can you talk specifically about 3101 to 3105 that you referenced?
Yes, certainly. Thank you. Section 3101 is the law that sets up how a road association is formed. And right kind of at the beginning of it, there's a portion that defines what maintenance is on a private road, what constitutes the maintenance that can be done by a road association. And one of the things that it says is that maintenance does not include paving, except in cases where the pavement was installed before July 1st, 2007, which is an easy date for me to remember because it's my granddaughter's birthday. That therefore roads that were paved after that, you cannot repair them because it says right in the law that maintenance only includes repairing pavement that was installed before then, or it can be used for paving areas where pavement has been shown to be a cost-effective method of controlling erosion, which is very important. That is allowed. But if you have just a straight section of road and you want to pave it, you can't under the law as it stands now. And what Mara is finding is that there are a lot of situations where a developer comes along after 2007, paves the road, and then turns it over to a road association. And what are they supposed to do with it? Then now they've got pavement that's beginning to deteriorate and they can't repair it because section 3101 says that they can't. There are also situations where somebody wants to form a road association. The people all want to get together and do it. But because the road has already been paved, they say, how can we form a road association when there's nothing we're going to be able to do? Yeah, they'll be able to plow the road in winter, but they can't fix the pavement. So what we're suggesting is that there needs to be some way either to get rid of that date or to say that there are situations where a road association can maintain or repair pavement that was existing before that wasn't existing until after that date. One of the suggestions is to specifically allow reclaim. Reclaim, by definition, is not the same thing as pavement, and it does not count as either paving or repair of pavement. It's like putting in gravel, but a lot of road associations don't realize that. So by putting it right into the law, we will say, okay, here's an alternative. If you can't pave the road because you're past that date, you can at least do reclaim. Or if there's existing pavement that is deteriorating, you can grind that up and turn it into reclaim. That's okay. Also in that section 3101 further down the page, one of the things that is allowed under the bill we're proposing is that road associations would be allowed to have a reserve account so that instead of saying, oh my goodness, now we've got potholes and cracks and we need $10,000 to even patch the potholes, we haven't got $10,000, what are we going to do? This would allow a road association to put aside a little bit each year until they've got enough to be able to do something to address that pavement. So that's another piece that's in there. Another piece that's in the proposed amendment is that 18 months expiration of notice of claim. And I believe some other people have put in written testimony online that will show charts of how complex this gets when you have one filing after another. And I know how easy it is to miss those deadlines because I've missed them twice. And I told my road association, obviously, I'm not a good person to do this. I've got too much else on my plate. You need to have somebody else take this over. And one of the other board members said, I'll do it. And I said, great. I sent her the forms to use. I sent her what the amounts were, who the people were that need to be filed. I sent her reminders saying, okay, the deadline is coming up. You need to do this. And she emailed me back and said, sorry, I'm too busy now. I can't do it. And then this last year, we had another board member say, well, I'll do it. And when it came around to it, he said, I can't do this. So we need to make this as simple as possible. I was there when they passed that 18-month expiration. And part of the motivation for doing it was to make things simpler for laymen, volunteers who are running road associations, because they know that this is, difficult. So let's make it easier. Let's just say you don't have to file the expiration because it's going to expire anyway. Well, the problem with that is then you have to file extensions. So now you're filing twice instead of once, and you're having to redo it every 18 months, which is staggered from your 1-year road association meetings. It just gets to be mind-boggling. It's hard enough to get people to serve on a road association board without also asking them to try to deal with this. One thing that I think is a factor that needs to be considered here is that there's been a fairly recent change in the realty laws that now requires disclosure if the property being sold is accessed by a road that is not publicly maintained. And what we found since this went through is that now when a property is about to sell, the realtor gets in touch with the road association and says, are there any notices of claim? Have they been paid off? Do we need to clear this up? When are the dues due? What is the amount of the dues? What are your bylaws? They ask us all these questions. And this is great because now we know that the property is being transferred and we can straighten all this stuff out. The one thing that I see as being a problem, we've been told that title insurance companies have a real problem with not having an expiration. Because say the road association folds, they can't find who to get in touch with. And that claim sits there and there's no way to show that it's been fulfilled. My suggestion would be, instead of having an automatic expiration, have something that says, if the road association no longer exists, then the claim is void. I don't know if there's a way to do that. I'm not familiar with that part of the law, but that seems to me like it would be most sensible.
All right. In closing, the Maine Alliance for Road Associations, that we received documents, says sponsors amendment. Are you suggesting what was presented specifically for 3101 to 3105 would be the only thing that you would like to see move forward?
Was there anything else that needs to be in there? Reserve accounts is included in it. The paving is included. The 18-month extension is included. The things that would not be included would be the inventory, and kudos to Pete Coughlin of the DOT. I think he's going to help us with a lot of that. It will still need some work, but again, because it still needs work, that can be held over. All of the clarifying of the definitions, that can be held over.
But-
Trying to define a private road. That can
Aren't
be
those
held
things
over.
outside of 3101 to 3105?
Those are all outside
Okay,
of that.
so just to be clear, 3101 to 3105 of the amended language is what you would like to see as most important that may want to move forward.
That may want to move forward now. Some of that other stuff, I think, don't just can it, but if we can
Correct.
hold it over and work on it, that would be great.
Thank you.
The one other thing that I would love to see in here is that, at least my husband brought up about the constitutionality of public easements. Because we have, and I've got that in my written testimony that you'll get later, and it's in his as well. There are 4 court cases that are
Yep.
in direct conflict with each other, and that needs to be sorted out because you've got, one case that says you can't have a public road without public maintenance because it will destroy the access, and that's an uncompensated taking. And then you have another case that says that a private way is a public easement, which is a public road with no public maintenance. Well, didn't they just tell us you can't do that? So I would love to see a question sent to the for an opinion of the Supreme Court justices on that to see how they sort it out. But I would want to put in paperwork to show them why it doesn't work. So thank you very much for that question.
Thank you. Any other
Any other-
questions?
And if you have any questions afterwards that you think of, easiest way to find me online is a Google search for Discontinued Roads Maine. On a Google search, it pops up right at the top. Some of the other searches it doesn't.
Okay, thank you.
Thank you.
Is there anyone else who would like to speak neither for nor against LD 461?
Roberta is a hard act to follow. Senator Nangle, Representative Stover, and distinguished members of the Joint Standing Committee on State and Local Government. My name is Carla Black. I'm the Deputy Executive Director of Maine Woodland Owners, speaking today neither for nor against LD 461, an act regarding private roads. The bill before you today makes a change to the definition of a private way in Title 23 to have the same meaning as a public easement and creates a new definition for private road. The proposed amendment drafted by Mara and circulated prior to the hearing eliminates the proposed definition of private road,
but in the forward suggests they are still gathering in an addendum, the 30 or 40 statutes that will need to be amended to eliminate the term private way and replace it with the terms public easement or private road. The addendum, as you've heard, will be available in mid to late April. This committee has made helpful changes regarding roads in recent years. You know the challenges with making changes in this area. The complexity of the task of finding all of the statutes that utilize the term private way and determining what word to replace it with is significant. It's a task that shouldn't be hurried. You have also recently created the Abandoned and Discontinued Roads Commission, of which I am a member, and tasked the commission with reviewing legislation of this nature when you request such assistance. The Abandoned and Discontinued Roads Commission met recently regarding LD 461 and recommends that this bill be held over until the next session of the legislature. This will give the commission time to work with Mara to review the terms in the addendum in a comprehensive fashion and provide this committee with its substantive recommendations. And Maine Woodland Owners supports this recommendation.
Thank you.
Welcome.
Does anybody have any questions?
Thank you.
Thank you. Is there anyone else who would like to testify neither for nor against this bill? No one on Zoom? Okay, so we'll close this public hearing.